Good evening, everyone, and welcome to the Track to Treaty, the process and progress of reconciliation in Victoria. I'm Lynn Haltane. I'm the Executive Director of the Victoria Law Foundation, and it is my privilege to be with you tonight and in conversation with our outstanding panel, whom I'll introduce you to in just a moment. But first, I would like to acknowledge the traditional custodians of this land and recognise their abiding connection to land, waterways and community. The office of the Victoria Law Foundation is on the traditional lands of the Wurundjeri, and this evening I'm on Bunurong country, both peoples of the Kulin Nation. I pay my respects to their elders and to all the generations who have nurtured this land for over 50,000 years and continue to do so. I also welcome elders and community members from all other nations who may be with us this evening. At the Foundation, we believe that acknowledging the past is an essential step in building a better and more equitable future. We recognise the impact of colonisation, its legacy of injustice and marginalisation of Aboriginal and Torres Strait Islander peoples. We are committed to making a sincere positive contribution to a better justice system for all of us, especially those most in need. Just a little bit of housekeeping. As you know, this evening we are in webinar mode, which means that only the panelists will be seen and heard, but we would still love to see your questions. So if you have something that comes to mind as you listen to the conversation, please put your questions in the Q&A area that's available to you at the bottom of your screen, and we will get to as many of those questions at the end of our conversation as we can. And don't forget, you can upvote other people's questions too. If there's something there that covers the ground that you're interested in, then just upvote, and that means it will come to the top of the Q&A list. There will be a recording of tonight's session, so if you have to leave to get kids fed or dogs out or deal with the usual evening routines, then please be aware that we'll send you a link to the recording, or if you want to share it with your friends and colleagues afterwards, then we'd be delighted for more people to see it. So we'll send that as a link in an email to you in the very near future. And we also have with us Megan and David, who are here as our Auslan interpreters, and we are very grateful for their assistance this evening as well. Let me introduce you to our panellists who have so kindly made their time available this evening. Ellie Patira was appointed as Deputy Secretary of First Peoples State Relations in the Victorian Department of Premier and Cabinet in April 2021. She has links to the Gunai and Ngāpuhi people of Aotearoa, New Zealand. She is a lawyer and a policy advisor with a Master's in International Human Rights Law from Oxford. Her experience spans constitutional, Indigenous and minority rights law and policy, both domestic and international. And before taking roles in government, Ellie has worked as an academic, in the corporate sector, for Aboriginal controlled organisations, and as an advisor during the Fijian constitution making process, which sounds fascinating in itself. Now, as a DepSec, Ellie is responsible for an extensive program with First Peoples in areas of treaty, truth and transitional justice, self-determination and cultural rights and protection. So as you can hear, she is absolutely perfect for our conversation this evening. Welcome, Ellie. Eddie Cabillo is with us as well, Aboriginal man with very strong links in both urban and rural areas of the Northern Territory. He's a Larrakia, Wajigan and Central Aranda descent. Is a lawyer also and a newly minted doctor, Dr. Eddie Cabillo, and throughout his career has been involved with the National Aboriginal and Torres Strait Islander Legal Services and the Royal Commission to the Protection and Detention of Children in the NT. Recently minted as a doctor, as I said, and is now working at the University of Melbourne in the law school as Associate Dean and Senior Research Fellow in Indigenous Programs. Eddie, fantastic to have you with us. Thank you.
Thank you.
Sue Ann Hunter is our next cab off the rank, a Wurundjeri and Narai Ilam Warang woman. She's Deputy Chair and Commissioner of the Yoorrook Justice Commission. Sue-Ann was the National Sector Development Manager for, and I hope I'm pronouncing this right, I want to say SNAKE, the National Voice for Aboriginal and Torres Strait Islander Children. She spoke to the Royal Commission into Institutional Sexual Abuse of Children in Care and sat on the working group for the National Framework for Protecting Australia's Children. So some extremely profound and important work. Sue-Ann trained as a social worker and has worked in the Aboriginal child and family welfare field for over 18 years, including responsibility for all the cultural, clinical, healing services at the Victorian Aboriginal Childcare Agency, and as co-chair of the Family Matters campaign, which was set up to end the overrepresentation of Aboriginal children in out-of-home care. Sue-Ann, welcome. And we were hoping to have with us this evening Dr. Carolyn Briggs from the First Peoples Assembly of Victoria, but unfortunately she's not available to join us this evening. So James Thompson has very bravely stepped into the breach. James is an engagement officer with the First Peoples Assembly, has very, very kindly up that mantle this evening. James, good to have you with us. There you are.
Thank you for that.
Can I just invite you, given I don't have a whole lot of info about you, can you just give us a quick summary of your life and times? You've got 15 seconds.
So yes, as you said, Lynn, my name is James Thompson. I'm a proud Yoorrook man from the Mooroopna region in the northeast of Victoria. I've been working for the Assembly for about a year now as an engagement projects officer in the metropolitan region, whereby my major role is to head out to communities and talk treaty, and also be listening to what our community wants out of this whole treaty process.
Once again, another really critical contribution to our conversation tonight about where we're up to in terms of treaty. So tonight is an opportunity to explore the progress that has already been made with a number of organisations that have been established towards reconciliation in Victoria. We're going to look at what is in place already, how far down the road we are, and what needs to happen from here, and try and get a picture of where we're at. A huge amount of work has already been done over many, many decades in this area. Developments like the ones we're going to talk about tonight don't happen quickly, and they rest on the shoulders of those who have fought and advocated and marched and consulted and debated and fundamentally waited for the rest of us to catch up, and waited for a government and a parliament that was ready to engage. In the last 6 years, though, that effort has culminated in the establishment of organisations and structures, which we'll spend a little bit of time exploring tonight, as we put together this picture of treaty and reconciliation in Victoria in 2022. But I thought I would just map a quick chronology, if you like, of where we're at, so that everybody's on the same page when we open up the conversation. So 6 years ago, in March 2016, the Premier announced that the state government would commit to discussing treaty with the Aboriginal people of Victoria. And then the Aboriginal Community Assembly was established in 2017 to work out what the representative body should look like. A treaty working group held roadshows all around the state, and I've read a wee bit about this, and it was a huge undertaking and a really impressive process to consult about the design of that representative body. And in 2017, the Victorian Treaty Advancement Commission was created to keep that momentum around treaty moving. The Advancement of Treaty Process with Aboriginal Victorians Act was passed in 2018. Really snappy title, but what it did was give the representative body status as the sole representation of traditional owners and Aboriginal Victorians on treaty discussions, which was a really important milestone. As well as setting a process for a number of other key elements, Treaty Authority, a self-determination fund, a treaty negotiation framework, and a dispute resolution process. So that act was pivotal in the development of these other elements. The representative body was renamed the First Peoples Assembly in 2019, and then the Assembly called for a truth and justice process in March 2021. As a result, we have the Yoorrook Justice Commission that was formally announced. And in June this year, as you may well be aware, legislation was passed in the Parliament which establishes the Treaty Authority, which is an independent umpire to oversee negotiations between the government and Aboriginal Victorians to ensure a fair treaty process. So a number of bits in there that I think we need to tease out and really understand. And there are sort of the three key organisations that I'm keen to give a bit of a, or get a bit of a grasp on. The First Peoples Assembly, the Yoorrook Justice Commission, and the Treaty Authority. So let's start with you, James, because we don't know how much time we have with you. And you work at the First Peoples Assembly. How did representation happen? I've read a bit about the roadshows and the effort that went into determining how that body might come together. But people are elected to the Assembly. What's the process?
Yes, that's correct. So as you mentioned in 2019, in December, that's when the First Peoples Assembly's members were elected. But before that, during November and September, we also had, those were when the elections occurred. So that's where our community came out and voted for who would best represent them on this journey of treaty. Within this, there are 32 members seats on the Assembly. Now, 21 of these are generally elected seats, so voted by our communities. We also have 10 reserved seats for our formally recognised traditional owner groups as well. So as I said, as of 2019, December, that's when those members were currently elected.
So when you say the general seats, is that the whole Aboriginal community of Victoria can vote across those 21 seats and the 10?
Oh yeah, so there are 5 regions that the Victoria split up into. Myself, I work in the metropolitan area. Each area has a certain number of members depending on density of population within Victoria. Right. So generally, I would say there's usually about 4 members out in the outer regions, and I believe in the metropolitan region there's about 8, I'd say. Okay,
so we've got an interesting process, I imagine, that sat behind that election in order to establish the makeup of that 32-person body and then to run the election, which is, now in place. I also understand there is an effort to look at elders' voices and youth voices through the First Peoples Assembly as well. Can you tell us a little bit about that?
Yes, so during our consultation with our community, we realised that it was exceedingly important that our community and our processes were led by, in particular, our elders, those being the custodians of our law and knowledge. We knew it was exceedingly important that any kind of legislative pieces we create needs to be steeped in cultural law as well as law. So it was really important that we had a committee that was there to make sure that our elders' voice was heard. Our members, Arnie Charmaine Clark and Uncle Andrew Gardner, are currently the co-chairs of the interim elders' voice. That being, they are currently going throughout the state, interviewing and talking with our elders and asking them exactly what they want an eventual elders' voice to look like. So that's currently the process for the elders' voice. And only just recently, there has been some work on getting representation for our youth in regards to this treaty process and making sure that their voice is heard during this process. I think it's exceedingly important that though we are on the journey of treaty now, who is most going to be affected by this is the future generations. So it's exceedingly important that we do get perspectives from both our past and our future.
Not that elders are past, they're present too, James.
Yes, of course.
I know what you mean. Just before, I move away from the structure of this, the First Peoples Assembly has done a huge amount of foundational work to establish the other dimensions that I put very briefly. So the treaty negotiation framework comes to mind, and the self-determination fund, and those sorts of elements. So given that you're an elected body of 32 members, how does that decision making happen? How are those thoughts brought to fruition and made concrete?
So as I mentioned before, so when it comes to information in regards to our legislative pieces, all of our members will come together and discuss these pieces. We were mandated to create these 3 pieces of legislation on our creation in 2019, but to the exact nature of them and the exact details for them, that was to be decided through consultation through our members. It's also key to note that during this process, it's been really key that we get our feedback from our community, whether or not that be someone like myself as an engagement projects officer heading out to community and talking about these key elements and asking what they want out of these key elements, or whether or not it's providing the opportunity, such as, I believe I think it was about March, I'd say, the treaty negotiation framework papers and the self-determination papers were released on our website for community to provide feedback. And there also was a treaty survey as well to provide further feedback. So all of this information is then collated and presented to our elected members. And from there, decisions are then made that are steeped in what our community wants, as well as the expertise and the knowledge that our members provide.
So it's critical that these structures and this process are grounded in First Nations culture and law, that the process itself is born out of the community's process and feedback and constant engagement. But I'm interested, Ellie, in the sort of government side of this process. How did you ensure that, from the government side, that this was going to happen? Or what was the requirement or mandate from government about how this process might be undertaken?
Well, I think the mandate really comes from the legislation passed in 2018 and subsequently going to election on the back of that well-established legislation. So I think the key parts of that legislation, which you've really pointed to already, is the pivotal role of the First Peoples Assembly as the sole representative of First Peoples in Victoria. And so really what the important space has been for the Victorian government is actually to step out of the role of seeking to gauge the temperature of community sentiment on treaty, stick very much to broader state interests, and really respect the Assembly's role in terms of coming to the table with positions informed by this really deep community engagement. And so that's been a new role for the government to play, where we're often negotiating in spaces where we both represent community and represent state interests at the same time. And I think that's been, a transformative move for government, because that's not the space we typically expect government to sit in.
That's right. And this is exactly, the revolution, I think, that the First Peoples Assembly represents. It's really quite remarkable when you think about it in those terms, that government, took that step, and, so they should, but it's really valuable, I think, as a model that the government has stepped away from that process and recognised.
And I think it's a constant process, and James would speak to this, I'm sure, as well, because it is an entirely new world for government to not control every aspect and not to control outcomes or how funding is going to be distributed. So to remove one's hands and really support self-determination, where you see the transfer of decision-making power and resources to an independent First Peoples Assembly, that is not the typical work of government. And it's really a reflection, I suppose, of that sovereign to sovereign relationship that is the fundamentally different relationship the treaty brings about. But it's constantly tested in government, because we're constantly pushing on how government operates day in, day out. And that will continue over, the next 5 to 10 years as we continue to build this relationship and this changing sort of respect for each other's sovereignty.
It's a peer relationship rather than a citizen government type arrangement, and as it should be. And that's embedded in this, which I think is really interesting. James, did you want to chuck in anything else on that score?
Yeah, I would say it's a similar sort of sentiment from the Assembly as well. This whole process is something that, as Ellie mentioned, it's a completely new way of understanding relationships between two sovereigns, as you said. So it is something that we at the Assembly are obviously working to our ability of, and also understanding that, as you said, it is a new process. So there are going to be hurdles, there are going to be things that do pop up that are unregistered or unaccounted for, but obviously through building this good relationship with the state as well, we're able to navigate those.
And so far, so good?
So far, so good.
Eddie, you've done some work looking at models around the world on these sorts of efforts to construct and develop treaty processes and outcomes. Is this how it's done elsewhere, or is this quite unique?
Well, this is unique for Australia. We've never had a treaty in this sort of sense before, whereas other countries, on being colonialized, that they had treaties and they've been broken, and that's still to be monitored, right? And look, Victoria, and I'm not from Victoria, so I don't want to pretend to know the country and everything, but I was lucky enough to be at one of the first meetings of the Assembly, and there was robust discussion and people with very different views, which is normal for any population, right? We just have to look to our parliament in Canberra and elsewhere to see that type of robust discussion and even look at the bad behavior in some of those places. And what I saw was real commitment to making change, and also the realities around what's needed, and we spoke just previously about the legitimacy people have to have towards their communities and their people and their laws and their culture, and that's an underpinning fact of any Indigenous governance is that legitimacy back to community and back to our strength of land, culture, and language. So it's not really new in a sense, because we've been doing it from prior to anyone else being in this country. And what the research says around the world is that if it underpins the governance of that structure of individual nations, and that usually get better outcomes than some of these corporate governances that are pushed upon our organizations and our peoples. So, and I see that in the maturity of the Assembly going forward, in how they have really, knuckled down and really care about what comes for their communities and their peoples. And I think that also will lie in good stead for Victoria overall in regards to better services and better outcomes and better use of government monies, and for our people, better education, better health, better justice outcomes, and it just goes on. And if we look back to the Royal Commission on Aboriginal Deaths in Custody some 31 years ago, there was a recommendation there around basically giving back self-determination to Indigenous peoples, because they know what's best for them and their communities. And we're still yet to really come to grips with that. And this whole exercise is, with government and communities have really allowed, each one to really discuss what is to give up, or what we're going to do to make the better outcome for the whole of Victoria, but predominantly for what's best for Victorian Indigenous peoples. And I think, and I speak to majority of those that I've dealt with on this journey that I've been involved with, that everyone's watching, all other Indigenous communities around Australia are watching And we're really hoping that they get the best outcome, because what usually happens is that'll be the benchmark for the rest of us. And so we're all hoping that Victoria really comes back with a model that's real for Indigenous Victorians, and that's something we can all point to and say we want something the same.
Yep. We'll pick up some of those threads in a minute, but Sue-Ann, I want to hear about Yoorrook. The Yoorrook Justice Commission. Yoorrook means it means truth in Wamba. So we have a Truth Justice Commission, which is an extremely powerful combination of words. I think putting those two together, you don't have justice without truth. And I think that's the very strong message that Yoorrook is sending. But before we talk about the Commission's work itself, tell me how you are handling language, because I know that there are a number of different parts of the Yoorrook process that are described using languages from different parts of the state, because that is also really powerful in ensuring that language is sustained and used in these processes is part of the justice, isn't it?
It is part of the justice, but it's also about being part of using our language makes people feel safe. It's also people understand it. They want to use it. It's helping a reawakening of language, but it also grounds us back in culture as well. And I think that's really an important step, particularly with Yoorrook, is that grounding and being built on those foundations of culture. And although we're a Royal Commission, this is different, uniquely different, and we need to do it differently. So by, to some people it might be a little thing, to our mob it's a big thing, and it actually starts to build trust and feeling safe, I guess, within that. But it's not just our language, it's the English language that we're grappling with as well. Language is so important of how we use it and what we say and the words we use. And it's very centered around, if I can say, the white man's law. And so what we have to really grapple with is making sure we make it a safe space for our people, and we're able to still hold the importance of it and keep people safe, culturally safe in the process.
So rather like the First Peoples Assembly, you have to create space which is distinct and perhaps different from the normal legal process that we are familiar with. As you say, that's a white legal construct.
Yeah.
And so it's important to create a different process within that, as I understand it. Is that fair description?
Correct. A really good example, and I think Ellie was part of this happening as well, is our first lot of hearings were held at Charcoal Lane. Instead of we could have easily hired a room that looked like a court sort of system, and we sat in round tables and everybody was on the same level. It was a place that people knew, so they walked in feeling safe. Now, our first person to give evidence was Uncle Jack Charles, and how do I put it? He's told, as we all know his story, but for him to tell it on that day was quite emotional. So we had elders coming to tell their story, but it was different. They were actually being heard, and they were telling their story for an outcome, to be part of an outcome for our people. So spaces need to be safe, people need to be held, and they need to be listened to. So even the best storyteller that's told their story 100 times, when they come to this space, it's quite different. And the fact that they're not cross-examined, they're just taken through their witness statement is another thing as well, because we don't want that for our people. We don't want our people being challenged on their truth. And so right through, we're talking about hearings out on country, going to people, just being in a yarning circle where Arnie tells this story for the very first time, that even though I'm a commissioner, I'm still mob, and I'll go over and I will sit next to her and I'll hold her hand and I'll give her a hug and we'll go and get a cuppa, because that's what we do to keep our people safe, and that's how we take them on the journey. So taking down those, those barriers of that don't make us human or don't connect us. There's a lot of that happening.
I understand that, James, you have to push off, which is sad, but we understand, and we are very grateful for the time that you've managed to squeeze in for us. So thanks so much for being with us, and best of luck.
Not a problem. Thank you so much for the time. Okay. And yeah, I just apologize. I'm not able to stay for longer.
No worries. We'll pick you up another time. Cheers. Coming back to Yoorrook, Sue-Ann, the hearing process takes time. How many? I mean, you've had hearings already. I'm sure that there are many more scheduled. How is that process working?
So the public hearings, I guess the first lot of public hearings, we chose the elders, as James was talking about before. We wanted really cultural authority within this commission. So we consulted elders in the first instance. We went out on country and we consulted elders. And to ground it, we needed their evidence first and their stories. And so they were our first lot of hearings. And I must say they stood up and they come to the party, and we learnt from those first lot of hearings. There's some more coming up in December, and we're going to start being a bit more thematic. But I forgot the question now.
Yes. So the whole hearing undertaking is clearly something that takes a lot of time. I know that you've had one extension, as I understand it, but I must admit, when I saw the timeframes, I thought that's not long enough.
They're very ambitious timeframes. For our mandate is historic and ongoing injustices for First Peoples within Victoria. So that's really 1788 to current. That's huge, right? And so how we fit that in that time frame, we know we're not going to get to everything. We know that. But what we are doing is being guided by our people and what truths come forward. Probably a good way of looking at it is we've already done the interim report, and so you'll hear the elders' voices in there. We've got another report due next year. And I guess, putting it simplistically, if we look at harms that are happening now, if we can address those harms within that report with recommendations that the treaty can pick up or the Assembly can pick up. And then our final report is that long systemic, how do we change these systems, and who's accountable, and what does that look like? How do we address it? How do we redress it? It's those, but you're right, there's a lot of work to do, and there's a lot of things that have to run consecutively in parallel. So we do have 5 commissioners, and we know that we're going to have to split up and hold hearings at different times in different places. The thing about the hearing, they're not all going to be public hearings. So how we take evidence, so to speak, is how people want to give it. So it's not your normal. So it could be artwork, it could be artifacts, it could be song, dance. We've had a script submitted. We're doing some supported submissions, or it might be an organisation. However people are comfortable in telling their truth and coming forward is how we want to make sure we're doing it that way. But it's an ambitious. It's really quite groundbreaking. I mean, no one's really looked at the issue of systemic injustice, and we're the first truth-telling body in Australia. So everybody's looking, and we're very, very aware of this. And it's a bit of, how to put it, building the plane while you're flying it, because we don't have a huge amount of time, but we also have taken our time in making sure those cultural foundations are built properly, because if they're not, you could easily topple over. And so we have taken our time in getting that right. And when we hit very soon, we're going to hit with a big bang, and we'll be, out there making sure that the voices of those that want to be heard are heard.
It sounds like a very strong foundation between, the First Peoples Assembly and certainly the Yoorrook process. But the other bit that I was just wanting to sketch in before we open up the discussion a little more widely is the Treaty Authority and how that's going to work. Ellie, can you give us a quick grounding in how the Treaty Authority is going to function? Because it's the newest bit.
Mm.
Sure, I definitely can. And in doing so, I want to acknowledge that I have negotiated on behalf of the state. I'm still a community member, but we had always intended that this would be a conversation with the Assembly who aren't available tonight. So I make that disclaimer to give full context.
Thank you.
You're right in saying that under the 2018 treaty legislation, one of the key elements, one of the most important elements, was a treaty authority, an independent umpire to oversee and facilitate treaty negotiations between the state and Aboriginal negotiating parties. We know this is so crucial because historically and to this day, we are not on equal footing with the state as a community. And so we need to make sure that we have that independent umpire able to not only facilitate in a positive way as we go through negotiations, but also to deal with disputes as they arise. What's really interesting about this treaty authority, and I think what makes it different from Canada or New Zealand or other treaty institutions that we see in other treaty jurisdictions, is the Assembly actually thought really carefully about how we decolonise the space as much as possible. So the natural tendency with a treaty authority is to establish it as a statutory body of some sort. The Assembly was really incredibly keen to make sure that there wasn't that relationship between Parliament, quite that direct relationship between Parliament and this body, given the absolute importance of it as an independent umpire. Mm. So what you'll see with the treaty authority is it has a novel legal form that has not happened before. It's actually established by agreement between the state and the First Peoples Assembly. That is the establishing document, is that contract, that agreement as between the parties. What sits alongside that is facilitative legislation that sets out the particular powers and some of the functions of the treaty authority, but it is not where the establishment of that body emanates from. So incredibly unique legal structure in its own right, and I think fitting and representative of, our attempts to do things differently and really honour some of the different ways of doing business. Another really, I think, important element of the treaty authority is that it is an all Aboriginal authority. So the independent umpire will have all Aboriginal membership. The importance of this again is that there isn't equal standing. The state has incredible power. It has often had tribunals and decision-making bodies entirely consisting of non-Aboriginal community members making decisions that impact all Victorians. And so this was a real, I suppose, a really important way of saying we are doing things different and we respect the fact that Aboriginal law and cultural authority that is brought into the process through the treaty authority and its all Aboriginal membership is something that the state can benefit from as well. And we see that not only in terms of Eddie talked about we've been doing this forever. We've been doing good, facilitative, robust decision-making amongst our communities forever. And I think in many ways we do that better and different. And so this is an opportunity to bring that into how the state might engage in its broader relationship. So there's some really interesting ways that we'll be doing things differently through this independent authority. Importantly, the state is accountable to that authority for its conduct. The treaty authority can make determinations and recommendations about the conduct of the state and how it must proceed in terms of procedural matters. It cannot make substantive decisions for either party, acknowledging the sovereignty of both entities, but certainly it's a fundamental difference from what we see in the native title space and in other spaces where we are really trying as much as possible to stay away from judicial review and court-based processes and grounding it in Aboriginal ways of doing business.
I want to come back to the native title because that's, I suppose, the model that is in many people's minds. You know, for the last 30 odd years or so, that's the structure we've been familiar with. But before I do that, Eddie, this sounds very well structured, self-reinforcing, very positive. But there is no doubt that, I mean, all of us, and more particularly Aboriginal and Torres Strait Islander peoples, have been through these sorts of processes over and over and over again, where there's been big promises and a big failure to deliver. I'm thinking all the Royal Commissions, Aboriginal deaths in custody that you mentioned, which is just, you know, extraordinary that we're still seeing Aboriginal deaths in Victoria in recent times. Are you more optimistic? Are you more positive about this arrangement than previous ones?
Look, I got to see what happens, to be perfectly honest. Like you mentioned, there's been that many, you know, Royal Commissions, and I've been involved in one, as you stated at the start, some 227 recommendations, which basically have not been implemented. And if we go back to the deaths in custody, some 339 recommendations that haven't been implemented as well. And it just goes on and on. But the one constant thing in all of this is our people keep rocking up, and we keep wanting to make change. And our people, you know, from our elders onwards, we generally want to make change for our people. And that's been the constant. And I think, you know, I think what we've seen here is that through the Treaty Authority, and that we see government willing to relinquish some of its power, and that's a positive in itself. But again, you know, Indigenous people, we really want to see commitment to these things, and the only way we can do that, because nationally we're 3% of the population, and I think in Victoria, I think it's Indigenous people are 1%, and so we need our friends. And those friends are the 97% or the 99% in Victoria. And we need them to really get behind the Treaty Authority and the Assembly, as well as get behind the Yoorrook Commission. These ain't all new, right? And I don't want to be disrespectful to anyone here, but we could go to all the recommendations in the coronials, in the inquiries, that Senate inquiries, parliamentary inquiries, and we get tired of reading the same old recommendations. And I think the hope is that the Yoorrook Commission can do their recommendations and be backed up by the Treaty Authority and the Assembly, duly elected people of Indigenous Victoria, to really get on those recommendations and really push public awareness, as well as making sure that the public gets on and say enough's enough. There's been a lot of money spent in these places, and it's not true fault of Indigenous communities. It's they're always trying to run organizations, service delivery on a smell of an oily rag. And if we go in this is around good governance, that these organizations can run these places with very limited dollars, very big caseloads, and get on with it and do the best that they can under hostile conditions. And the reality is we know good governance, as Ellie and Sue-Ann and others pointed out. And I think it's time that we stop reading the rhetoric in some of our major media outlets and really go and see what our community and our organizations are doing with very limited resources.
I might jump in there as well, because I think Eddie has, and our communities have every right to be circumspect about treaty and what is possible. And the thing is, a commitment in 2016 and legislation in 2018 doesn't guarantee treaty outcomes and treaty relationships into the future. And Eddie's absolutely right that it requires ongoing political will, and that requires support and allyship. It's going to be absolutely essential to hold the process in a good place into the future, and we shouldn't forget that.
So what does that look like, Ellie? What does allyship look like? What can we do as the other 98% to support this effort?
I mean, there's some obvious things in the national context at the moment. We have an upcoming referendum. There is no doubt that a yes vote in Victoria is absolutely essential to ongoing support for treaty. But I think more and more we'll see treaty claims come into the public arena. We'll see necessary public discussion about whether all Victorians support treaty and the treaty claim put forward by the First Peoples Assembly when it comes. What do we want in treaty? And I think that what we'll be looking to is, what is the public narrative? What is the public level of support for those things? It's going to be absolutely crucial to just how far we can push the aspiration of treaty, because that's still to be filled in. That's why Eddie's right to say there's work still to be done. So, I mean, we all know the different ways that you can show support for any political cause or any movement. And I think all of those avenues are absolutely important. As always, we say Aboriginal led, we're supporting and we're allies to Aboriginal voices. And it's not a matter of supplanting those voices, but.
Yeah, Ali, can I just add on to that? With Yoorrook, we've boiled it down to about 3 goals, which is truth, understanding and transformation. That understanding piece, and for the broader Victoria, we've got to bring them along. That's part of our mandate. And, you know, we can't do this alone, being 1% of the population. We can't get justice for our people, and we can't have true reconciliation within this state unless we all come along on this journey. So that understanding of our history, of the state, of this state, it's all our history, and we all have a responsibility to understand it. Unless we understand it, we can't do the transformation. And we really need people to understand. Part of what we talk about is, you know, past, present and future. And so we will make that link. We're happy to make that link, and we'll hold your hand through the process of understanding of how and why we are where we are as Aboriginal people, and why we need this. And you know, both Eddie and Ellie are right. Our people keep showing up. We're not going anywhere, and we keep showing up. And you know, I had a bit of a fear people aren't going to come and tell their truth. Well, they want to. They've told their story 100 times, but they want to come and tell it again, and they want to keep telling it again. And people want change. And you know, as mob, we're always working for the next generation. So that they get it better than we. But that understanding to bring about that transformation is really important. And, you know, people need to be informed, and I would say inform yourself about these processes.
Lee, tell us about how this works with native title, or you and Eddie may have positions on or perspectives on this, because I suppose we're used to that process. It is a very white structure around native title. How does it differ, and how will it work with treaties that are negotiated in Victoria? How does that sit against native title claims?
I might speak to 2 different things. One is the difference between some of the elements of the treaty negotiation framework as against native title, because I think there's some interesting differences. And then I might talk about the interplay with native title, because they're slightly different points. What's really interesting as we move towards negotiating treaty is the First Peoples Assembly. It was very important that groups self-determine their composition and how they will come to form treaty delegations for the purposes of negotiating treaty with the state. And so what you've seen in native title processes, but also in cultural heritage and in Traditional Owner Settlement Act processes in Victoria, is the state often playing the role of decision maker about whether the right people are at the table or not. What was incredibly important to the First Peoples Assembly is that it must be for First Peoples to make the decisions and to come together and reach agreement about how they form delegations and come to the table before inviting the state. So it's changing that power dynamic. That's a key feature of this treaty negotiation framework. What the Assembly, I think, would say they accept in that is that we might spend a lot more time in that agreement making period where our mob are talking to each other and coming to arrangements that make sense for mob. But that is self-determination, and that is a fundamentally different way of doing it than has been done before. And it also respects, and Eddie has spoken to Suad, our ways of doing agreement making, again, steeped in just thousands upon thousands of years of doing this and doing it well, and actually providing a space for it to be done, which just doesn't exist in other spaces. The second, more complex part of the question is, well, we can't divorce ourselves. Native title continues to exist in our world. So what does that mean? What's the interplay between the two? And the treaty negotiation framework acknowledges the fact that we are working largely within a Victorian jurisdiction. We'll look as much as possible to engage other jurisdictions to expand out over into borders and those sorts of things. But the reality is that we have federal native title law, and that cannot be ignored because we are negotiating treaty. And so I think there's a few elements there. One is that when it comes to matters that impact native title rights and interests, we have to make sure that delegations include people who hold or may hold native title and have duly authorised under relevant legislation. There's a way to do that while still honouring Aboriginal capacity to come together and form delegations. So we're kind of in this interesting dance where treaty aspires to so much more than what native title is able to deliver. And we are looking to do things differently, but we are still, the realities are, if we're impacting native title rights, that we have to make sure that we are looking to native title law and making sure we remain compliant with that law on the way through, always led by Aboriginal decision making around what rights are going to be pursued to decide which of those processes are going to be engaged.
So just to round that off a little bit, we understand what native title delivers in terms of access for particular groups. What would a treaty cover within a Victorian framework? What sorts of things would be the results of a treaty?
I certainly think we're moving in a different world in treaty, because we tend to see procedural rights in the native title space as one of the mainstays, which is not always that satisfying for us native title holders. I'm oversimplifying the scheme, but we're certainly looking for much more. I think the interesting thing in the Victorian treaty space, and we'll see this in the treaty negotiation framework, which is very close to being finalised, is that we're looking at both statewide treaty and local treaties. So local treaties covering off on traditional owner issues, land, water, economic development, based around country and our rights to country. The statewide definitely contemplates more of those institutional transformational changes as well. Political participation and representation, decision-making and delegated legislative power, functions in relation to all manner of social and community services, control of Aboriginal affairs dollars, the capacity and responsibility for deciding where those dollars might go. So we're really looking to the full gamut of Aboriginal control of Aboriginal affairs through our representative structures of our choosing. And that is, I think, the pinnacle of what treaty making can be. And that's why we go back to what Eddie says, which is it's going to require consistent support and political will over a period of time to broker these kind of the will is there now, but these are big topics. Some may require constitutional change depending on some of the decisions of the Assembly around what sort of legislative power they may want or may want to negotiate, because these are all up for grabs. And so we have to keep live to those possibilities.
It's a really interesting point. Political will is essential to this, and as one of our audience has pointed out, Matthew Guy went into the last state election as the opposition leader, stating that treaty was a federal issue and that it would not happen at a state level. But I think things have moved. Is that a fair assessment, that we are now on more solid ground in terms of a bipartisan position from this Victorian Parliament of both persuasions?
That's correct. When the Treaty Authority legislation was in Parliament and was discussed, there was bipartisan support for treaty making. The devil might be in the detail about the scope of what that treaty process might be, depending on who's in power, but certainly there is bipartisan support for the negotiation of treaties.
Sue-Ann, where does the Yoorrook testimony come into its own? As you've said, you've got this enormous span of history and tales to be told and heard and communicated. That is very powerful. How does it inform treaty negotiation?
All the evidence that we collect will be part of forming treaty negotiations. So it's part of what people have endured, what they see as the future, how that looks going forward. You know, it might be, for instance, child protection. We have a lot of people talk about stolen generations, and we have, you know, people talk about the system, you know, now. We can make recommendations around possibly some ideas of what that could look like. And then the treaty, the Assembly can pick that up and negotiate that. And that's the beauty of this commission, is that this all just doesn't go to government, it goes to the Assembly as well. And so that gives me great hope. And particularly, as Eddie said before, we've got recommendations coming out of our ears everywhere. There's been a lot of work already done about a lot of things. And also, the English were great at keeping records. Now, it might have been through a white lens, but, you know, you marry them up with the truth. When people say, did that really happen? You can sort of match them, and you can see there's a truth in there of our people. And we don't want our truth challenged. We want it to people to understand this is what we've endured, and this is what still continues. You know, thing that happened, it's happening, it continues today, it just looks different. And so getting people to understand why we need these changes and why these systems exclude us and don't include us, and the harm that it causes, you know, understanding the human side of that will bring people along, I believe, if people are open enough to listen and sit in discomfort. It's uncomfortable. It's really, really uncomfortable for people. But if we want to move forward and lead the way in Victoria, then, you know, a bit of discomfort is okay. But we are collecting the evidence for what treaty can actually pursue going forward.
You mentioned that everyone is watching, watching to see how it goes in Victoria, and that this might be a useful model, or, you know, if there are stumbles along the way, then there are lessons from those as well. But I'm really interested to know how we push this out. And you mentioned this too, Ellie, but the cross-border communities in the north of the state and in the west of the state, they don't stop on the drawn map. So I know that Yoorrook, for example, is taking testimony from people in New South Wales and possibly in South Australia as well. Is that a way, Eddie, that we can kind of creep over the border and start to influence New South Wales and South Australia for a start, in terms of putting some pressure on other states?
Can I just let people know that Indigenous people still practicing their laws ever since, you know, 1788. There's no borders for our people until someone finds gold or oil or something. Then there's an issue, right? Our people are still crossing borders, doing cultural exchanges, practicing their laws, you know, all that type of traditional lifestyle that we've always had. And it's, for some unknown reason, everyone else in this country thinks there is an illegal pluralism in this country, and it's really ignorant to understand that, right? We've got people who, you know, due to racial policies, had to adapt their culture, and it may not be what it was when, you know, when the first settlers rocked up, but no culture is stagnant. And those are the sort of mentality that we got to get past. And so do governments, corporates. We need corporates as well to jump on board with this stuff. And big institutions like the where I work, like a university, really need to change their mindset on all of this, how we teach the law, or how we engage with our communities, and all these sort of things. And there are already things happening cross-border legal gatherings, like across the APY lands in regards to the Northern Territory, South Australia and Western Australia. So this is not all new, right? And it is only when, and as Ellie said, when governments want to really work with communities that we can really achieve some of this. And in this instance, I think the Victorian government has relinquished some of its power, but now it's up for others to also take that lead. And as I think the co-chair Marcus Stewart said, that the power is now going to be handed back to Indigenous communities to really engage with how we make that significant jump from 1788 to the current process, where we have some respect that Indigenous people might be able to make some telling outcomes for themselves, right? Rather than getting put in a square box when we actually have some other ideas on how it best work for our communities. So I don't think it's outside the box. And I just think we as a nation, this really needs to respect that Indigenous people are continually doing what they've always done. And we step up, we turn up, and we really have those discussions.
And I'm conscious of time, but I will add the shortest snippet from a strictly legal perspective on the Victorian treaty process. And that's to say we've done two things in the negotiation of the framework. One is to allow for additional negotiating parties to come on board, and to allow for the negotiation beyond the jurisdictional limits of Victoria, in the hope that we may be able to influence other jurisdictions, so South Australia or New South Wales, to actually come into those negotiations, and that might even be pushed along by some of the national agenda as well.
We are going to have to wrap, and that's such a shame, because there are so many more perspectives to this that I would love to explore. But finally, I'd like to ask all three of you to give us a sense of what you think the impact of, for example, in your case, Sue-Ann, what are you seeing in terms of the testimony given at Yoorrook hearings and through the various means that that's being expressed? Is it enormous relief? Is it hesitance? Is it a great sense of being able to contribute to potentially a very positive development? All of the above? I'm trying to get a sense of the psychological impact, I suppose, of the opportunity to give your truth.
I think our people are really generous. The generosity of our mob to turn up for each other, even if they have a hesitance about what is going on. We've been promised a lot over the years. This is another, and we got it all the time, this is just another Royal Commission, right? And I can't guarantee that these recommendations aren't going to sit on the shelf, but I can tell you we're going to try really hard that they don't. And this is mob pulling together, because we need to change. Because if things don't change for us, it's just going to we're going to keep dying. Our kids are going to keep being removed. We know. It's not hope. I don't think we have hope. I think we just need to, be there for each other and push. We just keep pushing, and we we might not believe in some of the processes, we're particularly weary of government, particularly weary of royal commissions, but mob get up and show up. And so it's not resilience and it's not hope. I just think, we just need to do something different. Yeah.
Eddie, is this different enough?
Look, just looking at symbolisms, I went to both the Treaty Day Out and in Shepparton and in Bendigo, and just listening to non-Indigenous people talking and asking the questions, and I really think that they're up for it. And I teach that in the treaty subject at the law school, and I hear students the questions that they ask are deep and really meaningful. And again, I just think it comes back to the major population in regards to how we really push to make sure that this doesn't continue to happen, right? It's been happening for decades. The stories that Sue-Ann talks about, I was on a Royal Commission, heard the same stories from my grandparents, and I'm still hearing them now, right? And as a former lawyer and that, you see the constant cycle of families coming through the system, and it's the same issues, and something needs to be done differently. And here we have Indigenous communities saying, listen, give us the power to do what we know is best for our people. And I think we just got to get behind it and let Indigenous people prove that that's definitely what we need to do. And I think a former ATSIC regional chairperson, I look back and I see a lot of the programs that we established are still running. They came from grassroots and they're still running, and that really gives you heartened that grassroots people do know what's best for them, and I think we just have to have the respect that they do know that best for them and their communities.
I'm going to end on a slightly less glowing note, Ellie, and put this to you. What are the risks to this process? What do we need to be aware of?
I think it's been the common theme throughout, but it is that continued political will to deliver on the promises that have been made for, decades, but certainly the last 6 years. And I came into government to work on treaty. I never thought I would work in government, and I do it. And I think Sue-Ann's just said it so perfectly. It's not hope. It is a feeling that it must be, and that will continue to push and hope the political will continues to match Aboriginal aspiration.
And we all join you in that aspiration also. So thank you so much for your time tonight and for giving us the sense of where we're at in terms of reconciliation activity in Victoria, and especially the move towards treaty. We've had Ellie Patera, Eddie Cabillo and Sue-Ann Hunter join us, and earlier James Thompson too from the First Peoples Assembly. It's been an absolute pleasure having you with us also. I'd quickly like to thank my team for making it happen: Kate Sedgwick, Jackie Matthews, Helen Papadimitriou, for pulling this all together and did I say Kate Sedgwick? I think I did. I haven't got my script in front of me. And also to Dave and Megan, to our Auslan interpreters. Thank you so much for being part of our forum this year. Stay in touch with us and we'll keep you posted on future events from the Victoria Law Foundation. Have a lovely evening and go well. Cheers.